The purpose of pleadings is to identify the case which each party must meet and to identify the true dispute between the parties. A party can usually only obtain a remedy from the causes of action which are pleaded in its pleadings. So the parties work quite hard to ensure that the pleadings do properly capture the dispute. What happens though if during the trial itself it begins to emerge that a key allegation which goes to the heart of the dispute hasn't been pleaded? Should the judge remain within the pleadings, even if this means the judge must give an unjust ruling? This was the conundrum facing the first instance judge in this case. The case itself was one in which the plaintiff had invested in an apartment block off the plan. The developer was required to use their best endeavours to obtain the necessary approvals. It became apparent during the trial that the real question was whether they were required to use reasonable, not best, endeavours. So, whether a subjective or an objective test should be applied. After both sides had closed their cases and submissions had been made, the judge made that observation, and the plaintiff sought leave to amend their pleadings, even though the trial was essentially over. The judge granted leave and then found for the plaintiff. The unsuccessful defendant appealed on the basis that it was unfair that the pleadings were changed so late. The rule gave the judge the following power. For the purpose of determining the real question in controversy between the parties to any proceeding, or of correcting any defect or error in any proceeding, or of avoiding multiplicity of proceedings, the court may at any stage order that any document in the proceeding be amended, or that any party have leave to amend any document in the proceeding. The Court of Appeal noted the words "at any stage" and found that this included even such a late stage as the end of the trial. More importantly, they found that what was really happening was that the pleadings were being brought into line with the dispute which had actually emerged at trial, and that the question of the efforts made by the developer to obtain approval had been fully agitated at the trial. From this case, we learn that pleadings may be amended by leave, even at very late stages in the trial.